Bien, bienvenidos de nuevo. Yo me llamo Alfonso Iglesias, soy profesor de Derecho Internacional Público y en primer lugar quiero agradecer expresamente a Carmen Jerez y a Pedro Álvarez que, que me invitaron a participar en este proyecto de investigación y ha sido para mí un honor participar en él. Y por lo tanto voy a presentar moderar esta mesa redonda. Como ves, tenemos a tres ponentes. Dos de ellas van a hablar en inglés porque proceden de Rumanía y de Polonia. Las voy a presentar primero en idioma español a todas ellas. Sí, porque si no va a ser un poco como tal. Y después simplemente las diré que las doy la bienvenida y tal, y les expreso mi gratitud y eso. Y entonces la mecánica será que cada una de ellas tiene 15 minutos para hablar, como ya saben, y después abriremos la sala para que la audiencia, vosotros que queréis hacer alguna pregunta. Bien, vamos a comenzar. En primer lugar, os explico, está la profesora Cristina Popa Nistorescu, que procede de la Universidad de Craiova y que nos va a hablar de las acciones de la jurisprudencia de los consumidores, consumer case law. Y en segundo lugar, después tenemos a la profesora Dobrochna Bach-Golecka, que procede de la Universidad de Varsovia, Polonia, y nos va a hablar de las acciones colectivas, que son acciones, bueno, ya lo sabéis mucho mejor que yo, las class actions. Y en tercer lugar tenemos a Cayetana Santaolalla, Montoya, que procede de la Universidad Pública de Navarra y que, pues, no me acuerdo de decir.
No te lo he dicho. La vulnerabilidad del consumidor en el mundo digital.
De acuerdo, la vulnerabilidad. Muy bien, pues vamos a comenzar. Entonces, si no os importa, les doy la bienvenida un poquito en inglés. First of all, I want to give you a warmest welcome for coming here, and thank you very much for your willingness of coming and presenting your papers and so on as speakers at this Faculty of Law at this university under the work of this research project. And thank you very much for coming. First, you are Cristina. You are the first speaker. You have the floor.
Being a member of this wonderful research project, and also to thank very much to Professor Carmen Jerez Delgado, who invited me and gave me the opportunity to become a member of this research project and to present my research results at this conference. So my presentation is about the impact of the Court of Justice of European Union jurisprudence interpreting Directive 93 in the case of Romania. More than 24 years after the entry into force of the law, number 193, I will call it the Romanian law, which implemented the provisions of European Directive, the judicial practice regarding unfair terms in contracts concluded between professional and consumers is in Romania under the influence of requests to establish the unfair nature of certain terms in credit agreements. The main issues that have generated the controversies are the following: determining the unfair nature of a term, choosing the applicable sanction, determining the legal regime applicable to this sanction, assessing the cancelling effects produced by the removal of the unfair term, determining the degree of intervention of the court in the content of the contract. So the Romanian law, the directive was transposed by this 193. I hope you can see my my slides, my presentation slide, unfair terms in contracts concluded between professionals and consumers. I will start, because I don't have so much time, with the transposition of the directive in the substantive field and the procedural fields. Pursuant to Article 4 of the Romanian law, a term is unfair if it has been established unilaterally by one of the parties without the possibility of being negotiated or modified, and which produces a significant contractual imbalance between the contracting parties. But how is the notion of consumer defined in accordance with Law 193 for 2000, the Romanian law? Pursuant to Article 2 of the law, consumer means any natural person or group of natural persons constituted in associations which, pursuant to a contract under this law, act for purposes outside their commercial, industrial, or manufacturing, artisanal, or liberal activity. As one can see, law number 193, Romanian law, does not derogate from the meaning assigned to the term consumer by the Court of Justice of European Union case law. Romania choosing not to extend the protection offered by the directive to legal persons. This is the case of France, as I remember well. The opinion of the Advocate General in the case Horatio Ovidiu Costa versus Volksbank is case number 100. I don't know if I have to. Sorry. No, it's the next one. So the opinion of the Advocate General case in the case Horatio Ovidiu Costa Volksbank case number 110/14 is similar. Therefore, it is argued that no one can be deprived of the possibility of being treated as a consumer in relation to a contract which is outside his trade, business, or profession by reason of his general knowledge or his occupation, and instead regard must be had exclusively to his position vis-à-vis a specific legal transaction. In accordance with Article 2 of Romanian law, professional means any authorized natural or legal person which, pursuant to a contract under this law, acts within the framework of their commercial or manufacturing or liberal activity. Qualification of the unfair nature of a term. A contractual term which has not been negotiated directly with the consumer will be considered unfair if by itself or with other provision of the contract it creates to the detriment of the consumer and contrary to the requirements of good faith a significant imbalance between the rights and obligations of the parties. Thus, the conditions that must be met for a term to be qualified as unfair can be grouped into positive and negative conditions. Positive conditions are based on three premises: the non-negotiated nature of the terms, the determination of a significant imbalance between the rights and obligations of the parties, the breach of the obligation of good faith. The negative condition imposed by the Romanian law is that the clause under investigation does not refer to the definition of the main subject matter of the contract. The court analysis must be limited to the question or whether these terms are expressed in an easily intelligible language. As one can notice, Romanian law uses the phrase easily intelligible, which differs from the wording used by the directive, plain intelligible language. In this way, the national legislation provides an increased protection to the consumer, this possibility being granted by the directive to the member states. The negative condition does not have an absolute effect because the court will also be able to censor these terms where they are not clearly expressed in the contract. The Court of Justice of European Union case Andriciuc versus Romanian Bank has also defined the method of analyzing the plain character. It is not enough for a contractual term to be drafted clearly from a linguistic, grammatical point of view, but is necessary for such a term to be intelligible to the consumer from the perspective of the economic effect it produces. This is a judgment, Andriciuc. As you, Professor, you also explained in the morning. choosing the sanction applicable to the unfair term. Although recent cases seems to have focused on the sanction of absolute nullity, there have been some older decisions of national courts which established that the applicable sanction was that of unenforceability, noting, however, that the regime of this unenforceability was identical to that absolute nullity. So, nullity of unfair terms, if unfair contract terms are included, the sanction must lead to the removal of the effects of the term towards the consumer, gives the court the possibility of raising the unfair nature ex officio and have a value equivalent to the national rules relating to public order. Also, the law does not expressly regulate the incidental type of nullity. We consider the provision of absolute nullity shall apply, the reasons being as follows. Three reasons. The Court of Justice of European Union stated that Article 6 of Directive must be considered as a rule equivalent to national rule, which within the internal legal order represent the rules of public policy. The second reason, the Court of Justice of European Union recognizes the power of the judge to declare ex officio that the unfair terms of a contract are null and void, and to find that there is a public interest so that these terms, which are prejudicial to the consumer, will not produce effects. Also, is the High Court of Cassation and Justice of Romania that adopted the solution of absolute nullity, establishing that the purpose of finding the unfair nature of some terms is equivalent to finding their absolute nullity. The jurisprudential solution by which an essential clause is eliminated without ruling on the validity of the contract after the removal of the clause, leaving it up to the parties to negotiate a new clause meant to replace the removed one, does not clarify the fate of the contract. Therefore, if the court, through the consideration of the decision, establishes an obligation to negotiate, as long as the parties do not reach an agreement, the only solution available to them is a new action whereby they request the finding of the total nullity of the contract for lack of cause. Effect of the sanction applicable to the unfair term. As a result of the sanctioning of a term with nullity, the trader will have the obligation to refund the payments made by the consumer under the terms declared unfair, payments which, once the unfair nature or nullity is found, retroactively become undue payments, as well as any damage caused in the event of an action for damages being admitted against the guilty trader. And the National Authority also for Consumer Protection has the power to establish the existence of unfair terms in contractual matters and has the power to order civil and contraventional sanctions against the trader. Thus, in the case of an action filed by National Authority of Consumer Protection or a class action filed by a consumer association, the effects of the decision to establish the unfair nature of a term will occur erga omnes, which entails the obligation of the trader to remove that term from all standard contracts that will be concluded with the consumer in the future. Also, there is a new legislation that establishes that the trader will have the obligation to publish on its own website the final judgment. I have two more cases to continue. Unfairness of terms that may be subject to review by the court is the case number 143, Bogdan Matei and Ioana Ofelia Matei versus Volksbank Romania. So, as we know, it is a duty of the National Court to verify whether a term reflects the provisions of national law applicable between the contracting parties independently of their choice, or those which are complementary in nature and which are applicable in the absence of an agreement between the parties. In the referring court, found that the term in question was not covered by the aforementioned exception, it would be useful to examine whether it fell within the scope of the main subject matter of the contract or within the concept of the adequacy of the price or remuneration in relation to the services or goods supplied in exchange for them in the sense of Article 4 of Directive. The request for a preliminary ruling to the Court of Justice of the European Union in this case concerned the interpretation of Article 4 of Directive. That request was made in the context of a dispute between Mr. and Mrs. Matei and Volksbank Romania concerning the alleged unfairness of terms included in consumer credit agreements, which provide, on the one hand, for a risk charge imposed by Volksbank, and on the other hand, authorize the latter under certain conditions to unilaterally change the interest rate. As the Court of Justice of European Union stated in the judgment in Matei and Volksbank Romania, the exact scope of the concepts of subject matter and price within the meaning of Article 4 cannot be determined by reference to the concept of total cost of the credit to the consumer within the meaning of Article 3. Otherwise, the exception to the mechanism for reviewing the substance of unfair terms would be extremely extended, which would be contrary to the objective pursued by the directive. What was the impact of the Court of Justice of the European Union ruling in this case? It had been decided by final decision of the Romanian courts that the following clauses do not fall within the notion of the main subject matter of the contract. Therefore, they are subject to the review of the unfairness. Clauses on the risk charge, clauses on the interest increased 3 times above the legal limit, clauses on changing the variable interest rate in an unpredictable manner for the consumer, clauses on the management charge without the debtor having signed an addendum to the contract. The next case is the principle of monetary nominalism, case 186, Andriciuc versus Romanian Bank, which is the aspect that has drawn attention following the judgment of the Court of Justice of the European Union in the case Andriciuc and other versus Romanian Bank. The main aspect is the potential unfairness of the term establishing the consumer's obligation to repay the credit in the currency which it was granted. In the case of loans in foreign currencies, the question arose whether the client must make the payment at the reference level from the date of unblocking the loan or at that from the date of repayment, given that the exchange rate of the foreign currency had registered a significant change and the national currency had suffered a devaluation. Consequently, in the case, the contractual pre-formulated clauses were considered unfair, as they were obviously not negotiated directly with the consumer, and through them it was imposed that the loan be repaid in Swiss francs, regardless of the evolution of the exchange rate against the national currency on the date of payment. In conclusion, the Court of Justice of the European Union judgment in this case, Andriciuc versus Romanian Bank, has that contractual terms must be formulated in such a way that an average consumer, reasonably informed and sufficiently observant and circumspect, could not only be aware of the possibility of a rise or fall in the value of the foreign currency in which the loan was contracted, but also assess the potentially significant economic consequences of such a term on his financial obligation. The impact of this Court of Justice of European Union ruling, following the Court of Justice of European Union ruling is an Derecho case, many Romanian courts gave final judgments freezing the exchange rate of the national currency into the Swiss franc with the installments to be paid by borrowers at the exchange rate valid at the time of conclusion of the credit agreement. At the same time, the court also ordered the repayment to borrowers of the exchange rate differences collected by the bank. So I guess I should finish here. Thank you very much for the briefing.
Okay, thank you very much for your refreshing speech. Let's go now for the second speaker. Dobrochna, you have the floor.
Yes. Thank you very much for the kind invitation. I would like to express my gratitude, especially to Professor Carmen Perez Delgado, but also to Juan Damian Moreno for his speech during the pre-lunch session concerning collective actions. And I must admit that I, within the work during the project, found consumer law fascinating. It wasn't my first impression. And I also, due to this conference, came into the conclusion of writing my professorship book on consumer law. And I would strongly appreciate your comments, questions concerning my presentation, which would be not the summary of the project, because it's only 15 minutes and I want to stick with the time to have the time for the next speaker and possibly some questions and comments. But some remarks concerning the consumer law, concerning collective actions, and concerning some Polish framework, legislative undertakings and experiences concerning those undertakings. Also, one of the questions that I have that came to my mind within my research was the American impact on European consumer law. Are we to state that similarly to competition law, the EU competition law that was formed under the American influence, is EU consumer law also formed under the American influence? Or are there any other relationship between those two frameworks, which are connected to some regulatory questions, regulatory philosophies, the European philosophy being more based on a precaution principle, so more static, more passive, more constructivist, one would say, and the American approach, which is more experimental, risk-based, and oriented towards compensation in case of damage. And those questions are especially relevant within the collective actions schemes. And when one focuses on consumer law and the divisions, the notions that are built within consumer law, one may focus on consumer as a kind of basic term, which is similar, one would say, to citizen within the political sciences, the consumer protection laws and the enforcement of consumer protection laws. And this enforcement may be either public, administrative, which was the primary type of enforcement, and a private one connected to judicial enforcement, which was characteristic for the American style. I would like to focus, because I work at the Department of European Law, the EU impact, and the EU impact or the European Commission impact on consumer law are connected to gathering data, to the activities of various services. And I found the survey that was enacted yesterday. So it was a flash consumer confidence indicator that examines the opinions, the statements of the consumers within the European Union. and the activity of the European Commission that is based on regular reporting, monitoring consumers. So one would say that this is a very important, one would say, legislative scheme for the European Commission not to enact legislation out of the blue, but rather to monitor the internal market, monitor the consumers, and then to enact legislation. And then to enact not solely legislation, but policies, consumer policies. And within the consumer law, European consumer law, one should stress the dynamic development of the consumer law in the sense of 1970s, the judgment of the Court of Justice of the European Union in Cassis de Dijon, whereas consumer protection was not recognized as an element of EU law, to the development of the consumer policies and also the European Consumer Law, Article 12 of the Treaty on the Functioning of the European Union, stating that consumer protection is one of the policy guidelines as far as the EU is concerned, repeated in the Charter of Fundamental Rights, and also providing for specific competences of the European Union within the consumer law, within the division between the EU and the member states. I would also would like to add the international perspective, the development of the United States, the President Kennedy's 1960s impact on consumer law development with the articulation, identification of the 4 rights, consumer rights, and then also the United Nations, so the global perspective on consumer protection within the identification of consumer rights that are to be respected globally. And one may say that those legal developments led to the emergence of the modern political economy that is based on consumer protection. So somehow from nothing in the 1970s, we have come to the vision of a global economy based on consumer rights. And somehow one may say that if political order is based on the notion of citizenship, so the economy order should be based on consumer rights. And when one focuses on enforcement, because one may say that consumer law is a kind of substantive legal consumer law, so one may focus on procedural aspects, the enforcement or implementation, and within the EU, there is the notion of the consumer justice, the notion of this enforcement milieu. And within the European Union, it is a highly complicated multi-level framework, which is not only based on this public and private division, but one may focus on the ombudsmans, on the ADR mechanisms we were focusing before in the pre-afternoon sessions, and also on internal business run complaints procedures. And when one focuses on the judicial enforcement, on the topic that is connected to collective actions, one may focus on the grounding principle of the national procedural autonomy of the member states, but also on the various entitlements and rights enshrined in the European treaties that are connected to the right to effective trial. And one may also stress the role of an individual, of a person as a law enforcer in order to achieve this effective judicial protection, the role of a person, of a consumer as an enforcer of EU consumer law. There are certain recent EU developments concerning the consumer law, concerning certain technical and highly specialized legal acts dealing with various aspects of consumer law. concerning the claims procedure, the payment procedure. But one of the most interesting aspects is the introduction of representative actions, collective actions, or class actions. It is my idea that the EU is afraid of using the vocabulary that is too similar to the American one. It's not class action, but representative action, similarly to the Charter of Human Rights, which is not a Charter of Human Rights, but of fundamental rights, in order to have a notion that is European, but in fact it's human rights. And one may focus on the construction of those representative actions directive, which was developed within a very lengthy process of 20 years of preparing this directive, with the strong impact of academia. So my goal of this conference is also to produce something for the European Commission as an input of our academic endeavor. And one may focus on those statements that were included in the directive. And I may state briefly the Polish experiences concerning class actions that were introduced before the European Directive in 2009. Concerning the possible class actions initiated within the domestic order in order to protect consumer rights, which are weak in the sense that the instrument of class action is not very efficient. When one looks into the statistics, it is it's not very numerous class actions, as it's within the 15 years, it's around 300 cases. Some of them were rejected on procedural basis. And one may say that there are certain drawbacks that may impact the efficiency of the process of class actions. When one looks into the case study, I may briefly mention the Swiss loan credits case. Apart from the case law of the Court of Justice of the European Union, one may focus on the specific class action case that was initiated in 2014 and that had been evaluated negatively as far as the protection of consumer rights is concerned, in the sense of the court not willing to respect the evaluation of the Court of Consumer Protection, stipulating the abusive clauses in the contract, and also not implementing properly the adjudication of the Court of Justice of the European Union. So one may say a very lengthy process. The first judgment, the judgment in the first instance was given in 2022, which rejected the consumer protection claim, and one may see whether this lengthy process will eventually lead to the protection of consumers. But somehow one may focus on the involvement of other institutions within the judicial class actions, like the Office of Consumer and Competition Protection, or the Court of Consumer of Competition Protection, the Financial Ombudsman, the Commission of Human Rights, and also the municipal consumer ombudsmans who initiated the procedure. And one may say that within the evaluation of the class actions, one may say that what is important, what are the implications and suggestions that are presented within the case law and the doctrine of consumer law, is to try to develop the system of judicial protection of consumer rights that would be conducive to the overall judicial system. Certain cultural aspect of judicial system, in the sense of having a proper administration of justice, in the sense, for instance, to prepare judges to litigate class actions. There was also one proposal to initiate a separate court that would deal with class actions in order to prepare judges to deal solely with this type of actions. And in evaluation, I'm quoting Magdalena Tulibacka, who is a professor now at Emory University, but she had graduated from Toruń University in Poland, who participated as an expert within the process of drafting the collective action directive, and her evaluation of the consumer justice, the consumer rights enforcement, and the questions whether the present situation is the situation of consumers overprotected or underprotected, whether we should strive towards more American type class actions, or is the European class action efficient? It is a question mark. And we are going to also focus upon certain personal enactment, personal willingness of a consumer to litigate, whether the consumer protection should be based on this willingness to start judicial proceedings, or whether this consumer action should be more elaborate in order to enforce consumer rights fully. Thank you very much for your patience.
Okay, thank you very much for your suggestive presentation. Very clear at the same time. Pasamos a Cayetana, Santaolalla, cuando quieras, tienes la palabra.
Gracias, Alfonso. Gracias, Carmen. Es la primera vez que vengo a esta casa, a la Universidad Autónoma, y bueno, pues es un lujo estar con vosotros. La verdad es que ha sido un día súper ameno. Creo que todos los temas se conectan. De hecho, he hablado con varios de vosotros sobre estas cuestiones y creo que vamos todos en la misma dirección. Así que yo vine a hacer este proyecto con Carmen ahí en Roma, en Unidroit, y me encanta ver el bebé que hoy anda con este congreso y que... Bueno, muchas gracias, Carmen. Bueno, yo voy a hacer un enfoque breve, lo primero. Luego me voy a centrar pues, en la vulnerabilidad del consumidor, comentar un poquito algunas prácticas y algo de la legislación europea. Entonces yo, la primera reflexión que lanzo es, ya sabéis todos que tengo un marido agricultor, entonces mi pregunta es, si yo os planteara a vosotros, ¿no? Si os planteara a vosotros un hombre de campo, un agricultor, que no sabe ni hacer una compra online, y yo, que soy una mujer que conozco las leyes y que me manejo en el mundo de las criptomonedas, ¿creéis que somos consumidores vulnerables, alguno de los dos? ¿O creéis que esa potencial vulnerabilidad muta o es dinámica? Es decir, otra pregunta quiero lanzar. ¿Eres vulnerable ante alguien a quien quieres, en quien confías? ¿Eres vulnerable? Porque de alguna manera todas las empresas se prevalen de eso, de ganar tu confianza, de mantener relaciones duraderas en el tiempo, de conocernos todo lo que puedan, sacar toda la información efectivamente a nuestras entrañas y en un momento de euforia darles esa información que ellos quieren y exprimirlo beneficiándose económicamente de esa realidad. Entonces, inexorablemente todos sabemos que estamos a una velocidad de vértigo a un mercado, a un mundo digital. O sea, lo comentaba ahora, es que bueno, es maravilloso con Carmen. He hablado también con Dolores, que se me ha ido, ¿no? Sí. Dolores, Ruth, con Cristina, es que he ido con Paco, hemos ido hablando de todo. Entonces, en una primera reflexión seguro que decís, buah, el marido de Cayetano es vulnerable absolutamente, pero yo dentro de poco también, porque va tan rápido, que es verdad que en la legislación que hay ahora mismo en Europa, que qué afán por legislarlo todo, y yo diría que mal, es verdad que se quedan, hablaba con Paco ahora mismo, se quedan en vaguedades, en conceptos abstractos que no concretan qué es ese consumidor vulnerable. Porque sí, sabemos que un niño pequeño es vulnerable, mi hijo de 10 años es vulnerable, una persona mayor, mi padre, es vulnerable, una persona con una discapacidad, pero según los orígenes económicos, sociales, culturales, somos vulnerables. Y yo diría que lo vamos a ser todos. Y además al ritmo que va toda la digitalización. Por lo tanto, sé que hay una ponente que ahora os lo va a explicar muy bien, se busca esa equidad. Es decir, Luz, claro, es que se busca esa equidad en una relación efectivamente de igual a igual, que no nos quedemos ahí una parte débil permanentemente. Porque otra cosa, que lo ha dicho Juan, es que, claro, a los políticos, a las empresas, no les interesan las acciones colectivas. Pero ¿esto de qué va? De proteger al consumidor. Entonces tiene que haber una equidad que nos proteja. Entonces, yo ahora me viene también a la cabeza, bueno, por supuesto, el derecho a la competencia, que yo soy, creo en el derecho a la competencia y creo que efectivamente hay pues monopolios con muchos intereses que hacen que, bueno, pues que no sea tan interesante igual cambiar esas estructuras de poder, porque estamos pensando en, vale, definir el consumidor vulnerable, darle protección al consumidor vulnerable. Ya, pero si no controlamos esas estructuras que de alguna manera son las que generan esos desequilibrios para que seas un consumidor no mixto ni medio, vulnerable, y cuanto más rápido mejor, y que tú no pienses y que des toda la información que ellos necesitan, es que ¿hacia dónde vamos? ¿Tanta legislación? ¿Para qué? Entonces, yo creo que el consumidor vulnerable en este mundo digital va a ser la norma, no la excepción. Buscan eso, precisamente, esas vulnerabilidades. Y si estás capacitado y formado, pues yo voy más rápido y consigo esa información y sistematizo. Es muy difícil perseguir además esas conductas, porque vemos que la legislación es ambigua, es generalista, es abstracta. Entonces hay muchas carencias y aquí somos todos de derecho. Entonces, creo que proteger al consumidor sin cambiar las estructuras es inútil. Es decir, tenemos que ir a esos focos de poder que desequilibran constantemente las relaciones. Voy a poner unos ejemplos. Tenemos, por ejemplo, Google, Facebook, Apple. Tenemos empresas que les han multado una vez, otra vez por infracciones al derecho a la competencia, pero todas conectadas con los consumidores. De hecho, tengo Google, porque abusaba de los anuncios para publicar los productos que ellos estaban implicados, o porque promovía el comparador de precios, o porque preinstalaban los motores de búsqueda en todas las aplicaciones que querían en Google Play. Les ha multado, pero con 4,34 mil millones de euros, 2,42 mil millones de euros, multas, pero da igual, seguimos. Facebook, lo mismo. Le ha multado porque viola la privacidad de los usuarios, pero Facebook nos da todo lo que queremos, o sea, es un monstruo. Yo me he dado de baja, menos en LinkedIn, me he dado de baja en todo, porque me buscan momentos de vulnerabilidad y les doy la información que ellos quieren. Apple, lo mismo. Apple está teniendo unas batallas por su aplicación de Apple Pay, porque cobra unas comisiones elevadísimas, quieren monopolios, y todos prevaliéndose del consumidor débil, que somos nosotros. Por lo tanto, el derecho de la competencia. El derecho a la competencia a mí me hace relativamente gracia porque el derecho de la competencia, pues sí, lo tenemos regulado del artículo 101 al 108 del Tratado de Funcionamiento de la Unión Europea, tenemos leyes en España, hay leyes en Estados Unidos, hay por todas partes. Incluso la Ley de Servicios Digitales arroga a las autoridades de defensa de la competencia la posibilidad de sancionar. Pero digo yo, si luego no se respetan las decisiones de las autoridades de defensa de la competencia, si son sanciones administrativas que luego se recurren en vía judicial, se paralizan o se busca una irregularidad de procedimiento, que lo he comentado con algunos de vosotros. Es decir, que el derecho de la competencia estaría bien las infracciones que en última instancia distorsionan el mercado, distorsionan y afectan a los consumidores porque son precios más altos, peor servicio, peor innovación. El derecho a la competencia cuida todo eso. Es fabuloso, la teoría es fabulosa, pero yo personalmente creo que no se le está respetando. Las sanciones de las autoridades de defensa de la competencia no se respetan y no pasa nada. Entonces, a la legislación, he citado la Ley de Servicios Digitales, que bueno, tiene una definición de consumidor general, y hace esta alusión a las autoridades de defensa de la competencia, que en mi opinión no se respetan, y bueno, y hay, diría, sanciones y sentencias donde se han recurrido, o bien por fallos de procedimiento, fallos formales, o porque se han recurrido y no se han impuesto las sanciones. Tenemos la ley de práctica, la directiva 2005/29, que también dice que es desleal una conducta contraria a la diligencia profesional y que distorsiona el comportamiento del consumidor. Ya, pero concretar eso, es que me parece que está desfasado. Ese concepto del artículo 5.2 está desfasado. Hay que completarlo, hay que desarrollarlo, hay que modificarlo. Tenemos también el reglamento 2016-679, el Reglamento General de Protección de Datos, que María va a hablar de él dentro de un rato. Y yo creo que el enfoque de vulnerabilidad no está tampoco abordado en el Reglamento de Protección de Datos. Y también nos encontramos la Ley de Inteligencia Artificial, que van a hablar también, y sí que en el artículo 5.1b de la Ley de Inteligencia Artificial de la propuesta nos dice, vale, se puede explotar la vulnerabilidad de una persona física, un determinado colectivo, por edad, discapacidad. Aquí ya mete situación económica, social, se altera el comportamiento que produzca perjuicios. Pero insisto, la vulnerabilidad yo no creo, o sea, es universal, es ya la norma, no es la excepción. Y creo que hay que ir a controlar precisamente esas prácticas abusivas que distorsionan los mercados y que nos hacen a los consumidores cada vez más débiles. Y ya quiero cerrar, no sé cómo voy de tiempo. Creo que en esta sociedad digital se nos llena la boca diciendo, claro, que somos consumidores, actores económicos, pero es que somos ciudadanos, actores sociales también. Pero, oye, es curioso que para sistematizar toda nuestra información como consumidores y como ciudadanos, nuestros políticos, que ya sabéis lo que pienso, en la comida hemos estado hablando, no sé si hay alguno que se salva, nuestros políticos combinan todos esos datos para hacer todos los sondeos y utilizar todas las políticas, pero es que utilizan a empresas privadas. Oye, esas empresas privadas pueden acceder a toda información. Es decir, nuestros políticos deciden qué empresas privadas acceden a todos nuestros datos, porque hay algunas que no tienen esa superioridad de acceder a la información. También de repente hay filtrados de datos que son tan importantes y, oye, nos los roban los datos. Entonces, mi pregunta es, y cierro con dos preguntas. ¿La Unión Europea tiene la legitimidad que aparece en el artículo 114 del Tratado de Funcionamiento para dar forma a la sociedad digital a través del mercado interior? Es decir, ¿qué pasa? Además, ¿qué pasa con todos estos monopolios que lo comentaba ahora con Carmen? A mí me preocupan mucho las monedas digitales, las criptomonedas me preocupa toda la centralización de las decisiones. Entonces, todos estos monopolios que recaen en gobiernos, en empresas privadas, en bancos, ¿qué pasa con el consumidor? ¿Quién protege al consumidor? Yo creo que hay que dar una vuelta de tuerca y restringir, limitar, constreñir esas actuaciones para que cesen los monopolios y que efectivamente se defina mejor lo que es ese consumidor vulnerable y se le proteja de verdad. No se le rechace esa protección por intereses ideológicos, políticos, economicistas o de gente que está en una posición de superioridad y fuerza frente al consumidor. Gracias.
Muy bien. Cayetana, muchísimas gracias por tu interesantísima y refrescante ponencia.
Lo ha dicho todo.
Y, bueno, siento haber sido un poco perro guardián del tiempo. Time Watch Dog. Pero bien, ahora abrimos el debate para cualquiera que quiera hacer preguntas, observaciones.
Just a brief question for Professor Bach-Golecka.
Let's go. Yes.
So I have been seeing your slides, and so you have presented the case of a Swiss bank
Mhm.
But as soon as I am concerned, I think there were cases also from police courts, no, that were presenting prejudicial questions to the European Court of Justice, where the European concerning also this kind of multi-divisa, etc. And so I think the particularity of the police courts afterwards were to consider that the whole contract should be null and void, which is a very strong effect, no? Because here, for instance, courts have been some much softer, so to say, because the total nullity of the contract can be very prejudicial for the consumer, as the consumer has to give back to the bank the whole amount of money. And so why didn't you refer to these cases and you prefer to present the Swiss cases? And what is your opinion about this effect? If I am not wrong.
Yes. I wanted to present the class action case, which is at this time unsuccessful. But when one focuses overall on the protection of consumers within the Swiss loan credits, the majority of cases had been settled on the individual base, on individual litigation. So somehow it is the single judicial process that had been victorious. And the second in frequency method of solving the case was the mutual agreement with the bank in order to settle the dispute during mediation, which is very popular because it is a very speedy process. Once the court adopted the jurisdiction, the judicial verdicts of the Court of Justice of Luxembourg, then the bank got afraid, and somehow they speed up the process in order to avoid the litigation. Therefore, it's really an express process to get a part of the money. In fact, I and my husband also joined this process of a settlement with the bank, and the class action was unsuccessful in this process.
Okay, thank you.
I would like to, first of all, give thanks to Professor Cayetana and to both of you for your so interesting presentations. And I would like to make one question to each one, if we can. So for Professor Cristina, I would like to ask in a similar line that my colleague has asked, because in Romania, we have the same problem. We have that in several cases, as you have mentioned, Matei and Derecho.
The same action with Swiss.
It's Swiss francs, because you have this currency. The currency to pay was Swiss franc. The to fix was Swiss franc, and the currency to pay was also Swiss francs in the case of Romania, if I am not wrong.
Yes, but it's exchange rate freeze at the date of concluding the contract, not at the date of reimbursement of money.
And what happened? Did the judges declare usually the contract null and void, and then there was this problem of how to repay, or there was an agreement of what happened? Because in Banca B, for example, it was supposed that the judge had to try to an agreement to the parties.
Modify, and according to the law, of course, this is a difficult situation because, as you said, when you ask about this case, it is prejudicial for the debtor to null and void declare null and void the contract because they have to repay all they have to pay back. But right now, there is a modification in the legislation, the Romanian legislation, and action to declare the unfair of the terms of the contract is imprescriptible. So is a derogation for the from the civil code, and also in that special procedure of I don't know the translation of the procedure in English. This is a problem. Can this unfairness of the terms can be declared whenever, even in the process of execution,
Yes.
ex officio by the instance.
Yes.
And as I said before, a final judgment of the court is published on the website of the consumer, and all the contracts of those professionals are changed, and all these unfair terms are removed from the contract. So the future of these contracts is new for it's an obligation, a law obligation for the professionals to change all these kind of contracts. And it was the decision of the consumer to continue the contracts, they could continue the contract. But changing the unfair trust.
Thank you.
This is
The question is if I very with you to Professor Dobrochna. Can you explain just in a very summary way how it works? This institution so very interesting that you in Parliament, which is the Ombudsman, Financial Ombudsman, which we don't know have that in Spain. And I think that it's a very, very thing that have been very useful.
So it's impossible to state briefly, so I may consult you during the break, but somehow it is the Commissioner for Financial Consumer Rights.
Yes.
So he has various competences in order to start judicial proceedings, to enter judicial proceedings, to intervene within governmental institutions on behalf of financial consumers, and he may also intervene within the banks. So, for instance, my husband, when he held the office, he initiated negotiations with the banks as far as the mortgage holidays during pandemics were concerned. He identified abusive parts in the contracts, and he was successful. He initiated judicial proceedings, and with Santander, he won with Santander Bank.
Thank you very much.
Yes.
Okay.
Yes.
Muchas gracias.